Hello, my name is Charles Cowap, and in this series of slides shows I want to explain the way that planning blight, works in respect to farmland and rural estates. There are 4 of these presentations. The first one is going to deal with blight notices in general. In the second one we're going to take a more detailed look at the procedures that apply to a blight notice, and in the third one we're going to look at the particular complications around farms and blight. Finally, in the fourth of the 4 presentations, we'll be looking at the provisions concerning discretionary blight, and this will extend to some consideration of how HS2 is now being dealt with as well. The overall objectives for these series of web classes are these. We're going to be looking at the basis of statutory and discretionary blight. We'll explain what those mean in a moment or two. We're going to look at the procedures for a statutory blight claim, and we're going to have a look at the limitations of blight entitlement on farms. That should allow us to prepare valuations for blight on agricultural property as well as other property, and we're also going to round off with a discussion of some recent developments and their wider implications, for example HS2 and some of the procedures for nationally significant infrastructure projects which have been introduced over the last few years. We need to start by understanding very clearly that blight has a very strict meaning in compulsory purchase and planning. We're certainly not talking about potato blight, which you can see in the picture here, but nor are we talking about the general use of blight, where we so often mean it to take the general value depressing effect which news of a development can have in a broad area. We'll see what I mean by this as the slides unfold in a moment or two, but it's important to bear in mind at this stage that blight has a very strict and a very narrow meaning in compulsory purchase and planning. This is particularly true as far as statutory blight is concerned. So we're going to look at blight notices, we're going to look at the procedures which govern blight notices, we're going to look at the compensation which flows from a blight notice, and we're going to be considering discretionary blight as well. The idea of blight procedures are that they're used to force an authority to purchase property from you because your property effectively has been blighted by public development proposals. For this reason, blight is often called compulsory purchase in reverse. But these procedures aren't available to anybody and everybody. We need to consider who qualifies to serve a blight notice. In other words, what is a qualifying person. We also need to consider just what is blight. As I've indicated, it has a very narrow meaning, and we're going to look at the procedural aspects and compensation as well. So, who qualifies? You've got to be one of these 3 categories listed on the screen. You can be the resident owner-occupier of a dwelling house. That means you've lived there for at least 6 months. You can be the owner-occupier of commercial property, but you must be the owner-occupier. There's a limit to the rateable value which can apply to your commercial property. It must be less than £34,800. Slightly lower figure in Scotland, £30,000 there. And by owner-occupier, we mean somebody who has an owner interest in it. That most obviously means a freehold interest, but it can mean a leasehold interest if there is more than 3 years to run on that interest. In other words, anybody whose property has an annual value higher than £34,800, or who is not in occupation, or is only in occupation under a short lease, won't qualify for protection under the statutory blight procedures. Owner-occupiers of agricultural units also count, and again, owner-occupier most obviously means the freeholder. It clearly excludes the landlord who is not in occupation, and it also excludes the shorter-term tenant. But again, a tenancy which has got at least 3 years left to run on the lease can count as owner-occupation for this purpose. So that's a qualifying person. The property itself must be blighted, in whole or in part. Being blighted has a very particular meaning in compulsory purchase and planning. You have to look at Schedule 13 of the Town and Country Planning Act of 1990 to see the full list of what counts as blighting development. It's a long list, and I don't propose to recite it all in these slides here. It's a matter of easy reference if you are concerned that your property might be blighted. But items like road proposals, designation in development plans for public authority functions, or indeed being subject to a draft compulsory purchase order or land allocation in a special act for compulsory purchase, all count as examples of the sort of thing that lead to your property being blighted. Note that it's your property which must be blighted. So in other words, these proposals must be on your property. It's not enough to say that these proposals are made for property nearby. They must be directly requiring some or all of your property. Not only must your property be covered by one of the types of land use specified in the Town and Country Planning Act, but generally you must have made reasonable efforts to sell. And those reasonable efforts to sell must have failed, other than at a substantial discount. However, that requirement to try to sell your property does not apply once a compulsory purchase order has been confirmed, but land has not been taken yet, nor does it apply where a special act shows what land of yours is required for the development. So, we have seen that you must be a qualifying person. There are 3 categories. And we have seen that you must be blighted, or your property must be blighted in the statutory meaning of that term, and you must have failed in your attempts to market the property, unless compulsory purchase is at a much later stage, where either the compulsory purchase order has been confirmed or the land is shown as required in a special act. We'll next go on to look at the procedures behind blight claims in the second of our 4 presentations on the topic of blight generally. Thank you for your attention.